just to refresh your memory, what is charge? Charge is a very specific, precise, specific, and clear, unambiguous allegation against an accused that he has committed offense or offenses under a specific provision of law. So far as the contents of the charge are concerned, they are given in section 211, and the contents, as we discussed, that in charge, if the provision of the law, section of the law, if that specific offense is defined, has been given certain name, that name, if name has not been given, in that case the entire definition must be in the charge. Besides that, it must be in the language of the court, and if there is any previous conviction, it must be mentioned in that charge. Okay, it was section 211. And one more thing, that if there if it does not fall any certain legal condition, in that case there must be a statement which is equal to that it does not lie or fall under any legal conditions. We discussed yesterday. After that, section 212, which provides that whenever the charge is framed, the name of the victim and vicinity must be given, as it says that the charge shall contain such particulars as to the time and place, vicinity, time and place of the alleged offense, and the person, if any, against whom. It is not always necessary that there is always a victim, but in most of the cases, there is always a victim. There is a victim against whom, or the thing in respect of which, if the offense has been committed against things, against the property, it was committed as per reasonably sufficient to give the accused notice of the matter with which he is charged. These things are also essential. You know, what is the purpose of the charge? The purpose of the charge is to give advance an advance notice to the accused that he is going to be tried for this or that offense. The proper notice, what does it mean? What is the meaning of proper notice? For that, it must also be given that the vicinity where he has committed, time and place, vicinity means time and place where he has committed that offense, or against whom that offense was committed. After the section 213, so clause 2 is not so important. Section 213, when the manner of committing offense must be stated. It is very important. And there is a fine distinction in this. When the nature of the case is such that the particulars mentioned in section 211, which is about the contents of the charge, and 212, which we just talked about, vicinity, victim and vicinity, do not give the accused, despite of being all things given in section 211 and 212. All things mentioned in these two sections have been given in the charge, but the situation is like this. Despite of that, accused do not give the accused sufficient notice of the matter with which he is charged. All things have been given in the charge, but even then, the accused claims that he has not sufficient notice. Sufficient notice here means that he is not able to understand for what he is going to be tried. Okay. The charge shall also contain, if this is so, okay, in that case, the charge shall also contain such particulars of the manner in which the alleged offense was committed as will be sufficient for that purpose. It is a little bit technical. Okay, I give you some example. For example, theft is committed, the murder is committed. It is not required to give in the charge the manner of committing theft. Manner. I'm sorry, I'm extremely sorry. Call from the star office. Sometime obviously all the calls are from offices. Okay. Yes, what we were talking about, broadly speaking, there are two categories of the offenses. In category first, we need not to give the manner how that particular offense was committed. If a murder is committed, that's enough. Committed a murder of B, that's all. If A has committed theft in a house, it is not necessary to give that the how A has entered the house of B. Whether he entered by the door or he jumped the wall, it is not necessary. But there are certain offenses, or rather, we can say the complex offenses, where it is required, it is necessary to give the how that offense was committed or the manner of committing that offense. For example, cheating. What is cheating? As theft. What is the theft? We come to know by the ingredients of the theft. Okay, it is a theft and it's enough. It was a theft. Theft means whosoever intentionally, dishonestly takes some movable property out of the possession of somebody without his consent, and in doing so, if he moves that property, movable property, is said to commit theft. If the ingredients are fulfilled, that means the offense of theft was committed. In the like manner, what is the cheating? Cheating is something when somebody A pursue B to deliver certain property or to do certain act, and on his persuasion B does some act. A himself does not do any act. A induces B to do something. It may be the delivery of the property, it may be something else, it may be getting the signature, and it may be getting the property, etc. etc. Okay. So this is the offense of a nature where sometimes it becomes necessary to explain and to give in the charge how that cheating was committed. Okay, the manner of committing the cheating, it will become more clear. For example, if there is a contract between A and B, a number of transactions take place between A and B relating to that contract. Number of transactions. But in some particular transaction, A cheated B. Not in all the transaction, but only in one transaction. And it is not always necessary that the form of the transaction of all the transaction is same. It may be different. In like cases, sometimes it becomes necessary to mention the manner of the commission of the offense, how that offense was committed. I am reading it again. It will be clear to you. When the nature of the case is such that the particulars mentioned in section 211 and 212 do not give the accused sufficient notice of the matter with which he is charged. The charge shall also contain such particulars of the manner in which the alleged offense was committed as will be sufficient for that purpose. Accused A, in the case of cheating, for example, in cheating, A may claim that I have not committed any cheating. If there are number of transactions, in that case, it has to be mentioned particularly about that transaction where the cheating took place. So this is section 213. Any question? Now section 215. Leave 214, 215. And whatever sections are being discussed, please note down all those sections. Now the question is, a charge is framed, and after that trial begins. Okay, and the finally judgment is pronounced. But at some stage during trial or even at the time of pronouncement of the judgment, the fact was disclosed, or it was disclosed, or it came to the knowledge of court and the parties, etc., anyone, or to understand properly in the notice of court, that some charge had wrongly been framed. Are you getting this? Charges were framed, and during the trial, all of a sudden, or by during the evidences, when the witnesses were giving their evidences in the court, during the trial, at any stage, somehow it was disclosed that, oh, the charge was, whatever charge were framed, that were wrong. This person, this accused, has been wrongly charged. In that case, what will happen? Will the trial vitiate, or it is very important to know about this? Will the trial again take place, or will the benefit of this mistake go to the accused? The answer is lying under section 215. Okay. What does section 215 say? Effect of errors. Errors means any mistake, any wrong charge. No error in stating either the offense or the particulars required to be stated in the charge. Any offense, suppose sometime the wrong offense was mentioned in the charge, or even the facts were wrong, the particulars were wrong in the charge, and no omission to state the offense or those particulars shall be regarded at any stage of the case as material. It is not material. It is not important thing. If anything wrong has been mentioned in the charge, if there is any omission, any error in the charge, it doesn't make any difference unless it is not important. Unless, this is the general rule. It doesn't make any difference is a general rule. Unless the accused was in fact misled by that error, by that mistake, by any misstatement, wrong statement in the charge, if unless if the accused was in fact misled, if the accused is claiming that I was misled by this error, and he has to prove it, misled by such error or omission, and it has occasioned a failure of justice. So there are two things, three things. First, the general rule is this: if any error is done, it doesn't make any difference on the trial. Okay. Second, but if this error is somehow misleading, is misleading to the accused, and because of this misleading, some injustice was done to the accused. This misleading has occasioned a failure of justice. In that case, this error is important, and the trial will take place again. Okay. Trial will take place again. There will be retrial. If that error, the general thing is this: error doesn't make any difference. If there is some error, no issue. But if by that error, accused claims that I was really misled by this error, and because of this misleading, some injustice was being done or is done to the accused, in that case, there will be retrial. Okay. It will become to you, clear to you by going through the different illustrations given in this section. So, do you get this point? For example, we just discuss an illustration of cheating. Suppose in the same illustration, there are number of transactions between A and B. Hmm? And in one transaction, there the offense of cheating was committed according to B. Okay, charge is framed, as there were number of transactions, and if and the some error was done at the time of framing of charge, and if in the trial that A proves and claims that I was thinking, because suppose there are 10 transactions, suppose transaction 1 to 10, and the charge was framed for the transaction number 5. Okay. If the accused says that, okay, I was thinking about that this charge was framed about the transaction which took place in transaction number 1. There are 10 transactions. The actual offense was committed for the transaction 5, and some due to some error, the accused is considering it is about the transaction number 1. Okay. And if he says that I was misled, because what is the logic? What is the purpose? The purpose is that so that the accused could defend his case. So how a person can defend his case? Unless he knows about that. it is just for example, the suppose A defending his case, keeping in his mind about the transaction number one. Things are not so simple, it is just for the sake of example. But it was actually transaction number 5. If such situation arises and the accused is able to satisfy the court that I was really misled and due to this misleading, some injustice may be done to the accused, in that case, the retrial will take place. Okay. After that, section 216. What is section 216? When the charges are framed, trial begins and it reaches to the stage of pronouncement of judgment. Now the question is whether the charges which are already framed, can any one of those charges or the charge be altered at any stage of trial? Charges have been framed and the further proceeding starts, that is the trial. But at some stage in the trial, the court thinks that, or the party claims that we want the alteration in the charge, amendment in the charge. Question is that possible? The answer is yes, it is possible by virtue of section 216. You may have watched so many times in Hindi movies. Whenever there is a court scene, everything, entire trial is about to end, and the judge is about to pronounce the judgment. He just about to pronounce the judgment. All of a sudden, a person appears in the court. Stop, Jassa. I have to disclose something. And after that, the entire scenario is changed of that case. So what is that? How it is possible? Because it is possible because the charge can be altered at any time till the pronouncement of judgment. And obviously not after the pronouncement of judgment. But till the pronouncement of judgment. What does section 216 say? It says that the court may alter charge. Any court may alter or add to any charge at any time before judgment is pronounced. Any court may alter and may also add. Add means some new charge. Charge is already framed. Okay. Close to every such alteration or addition shall be read and explained to the accused again. Because it is the condition of the charge shall be read over to the accused and shall also be explained. If there is some alteration, some addition in the charge, again it will be read over to and explained to the accused. Third, if the alteration or addition to a charge is such that proceeding immediately with the trial is not likely, but in the opinion of the court to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may, in its discretion, it is the discretion of the court, after such alteration or addition has been made, proceed with the trial as if the altered or added charge had been the original charge. Now the question is the charge was amended, altered, or some charge was added. As the charge is very basic thing, the question is what should be done with regard to the trial? There should be retrial. But here certain discretion is available to the court. Court has to decide, court has to apply its mind that whether this alteration or addition is going to adversely affect the accused or the prosecution. If it is not going to affect or it is not prejudicial to the accused and the prosecution, in that case the same trial will continue. Charge is amended, charge is altered, added, but the trial will remain same. But it has to be decided by the court. But see, clause 4, that is, and which generally it happens, not given in the clause 4. What does it say? If the alteration or addition is such that the proceeding immediately with the trial is likely, in the opinion of the court, to prejudice the accused or the prosecutor, as aforesaid, the court may either direct a new trial or adjourn the trial for such period as may be necessary. But if the court thinks that it is going to prejudice the accused or the prosecutor, in that case, the new trial will take place. And see, this is the importance of the charge. Charge can be altered, can also be amended. Okay. But if it is going to prejudice the accused or even the prosecutor, in that case, the retrial, new trial will take place. That means the entire exercise during the trial is wasted. Okay. Clause 5th, if the offense is stated in the alter or added charge is one for the prosecution of which the previous sanction is necessary. We have read sanction, the importance of the sanction. Clause 5 says that if in a case, suppose that the trial is going on, but all of a sudden a new charge is added. But in that charge, for that offense, suppose it is a new offense, and incidentally, in this new offense, certain sanction is required, previous sanction of the government. It is about that the previous sanction is necessary, the case shall not be proceeded with until such sanction is obtained. In other cases, the sanction was not required. It's okay. But new case has come, new charge has been framed, but in this case, the sanction is now necessary. This case will not proceed unless there is sanction in the new case. Unless sanction had been already obtained for the provision of the same facts as those on which the alter or added charge is founded. If the offensive nature of the offenses or the offenses are the same, and somehow the sanction has already been taken for those offenses for which the trial is going on, in that case, the no sanction is required. It is about section 216. I think time is up. Oh, you will have to attend other classes also. Okay, we are meeting tomorrow. I think tomorrow.